Okay, well, good morning, everyone. My name is Jake Spear. I'm the director of the State Library, and thank you all for being here today for an important webinar on a really timely topic regarding COVID. Sherry Harris will be presenting soon, and I just want to mention that Sylvia Watson will be monitoring the chat and be able to answer any questions you have as we go throughout the presentation. As the library community continues to recover, please continue to utilize the staff at the State Library. Sylvia is available to answer questions regarding policies and procedures, and our legal memos that started at the beginning of the pandemic are available on the State Library's homepage. The link is in the upper left corner under COVID-19 resources. Sherry is still available to answer any questions regarding public library certification that you may have. Jennifer Clifton is available to answer public library standards questions. The Professional Development Office is here to provide training to your library. And just keep in mind that the Professional Development Office has been offering the What's Up Wednesday training that has been focusing on Inspire and other topics. And so you can find out more information about those trainings on our webpage. Just wanted to mention that many libraries have applied for either the first or second, in some cases both rounds of the CARES Act funds. And those claims for reimbursement from both rounds of the grants are due April 15th, 2021. So you have about a month, or about 2 months out for those. So again, thank you all for the work you're doing to provide library services during a really challenging times. And just please remember that the State Library is here to assist. And we're all kind of in this together, working our way through these things. So I'll turn it over to Sherry Harris to begin the presentation. Thank you.
Okay. So one of the most exciting developments that has occurred since the onset of the pandemic has been the great news that we now have 2 vaccines approved. Hooray, right? This is a light during a long, dark tunnel that we've been going through together. And it has the potential to generate a lot of questions. And so we're hoping today that we might be able to sort of pre-answer some of the questions you may have about what you can and can't do as an employer, and also what your rights would be as an employee. So we're going to touch on a number of things relating to that, and it's fairly dense material, and so I've tried to consolidate it as well as I can, and we'll try not to get bogged down. Let's see, the first thing I always do is start a little bit too fast. I just really, okay, I'm going to use, okay, let's try that again. Like any good attorney, I'm going to start with a disclaimer. The purpose of this webinar is to provide general information rather than legal advice. The information that is provided here is not provided in the course of and does not create or constitute an attorney-client relationship. For legal advice specific to your situation, please contact your library attorney if you're viewing this from the perspective of an employer, or your personal attorney if you're viewing this from the perspective of a staff member. And just to be clear about what I am covering and what I'm not covering, the information here is current as of today, February 18th, 2021. But it is subject to change at any time, and there will be a couple points during the presentation where I mention the importance of following a couple of agencies' websites to make sure if things start to change, if the pandemic slows down, if we are no longer in the midst of a public health emergency, then some of the things that, for example, CDC has said about, and the EEOC have said about how you can find whether or not, how the pandemic impacts the determination of whether or not there's a risk that you, as an employer, need to take account of. Those things can change too, as some of these other factors change. So information is current today, I hope, but it could soon be not so current. And also, while I looked at federal law, my remarks are specific to Indiana. And I have not reviewed any other state or jurisdiction statutes in preparing this webinar. Okay. So moving right along. This is a little bit of a outline about where we're planning to go. My goal for today is to begin the discussion of what an employer can and can't do regarding vaccine policy. And as I mentioned earlier, that also has the effect of introducing what the rights of an employee are when it comes to an employer's vaccine programs. This is what we'll be looking at, and it certainly will not be the final word on those topics either. I will take questions at the end, and if there's time, I may take some questions before the end. Having extra time is not usually what happens in my programs because I try to fill them up. Here are a few quick facts about vaccines from a 2016 Law Journal article called Who's Calling the Shots? And so Edward Jenner created the first smallpox vaccine in 1796, but similar methods had been used in ancient China, Egypt, and Turkey. In 1999, the CDC declared vaccinations one of the 10 greatest public health achievements of the 20th century. And yet, despite monumental results preventing the spread of disease and death, vaccines have never been universally accepted. Because of that last item, legally, this has resulted in a certain amount of tension between a state's interest in protecting the health of its citizens and individual interests, which tend to create growing pressure for increased number of exemptions to statutes or requirements for vaccines. Like I said, that's a brief background. So in order to create a framework for the rest of our discussion, I wanted to give you an overview of some of the different possibilities, some of the different choices that are available to you when you figure out how you want to, if you want and how you want to create a vaccine program and policy. So essentially, as far as I can tell, there are 3 different types of programs. An employer can encourage and educate their staff about vaccine availability and safety and make sure that information is ready and available. Or an employer can create a voluntary program where they are not requiring staff to get a vaccine, but they are providing some sort of incentive or reward for doing so. And we're going to talk about a number of factors that relate to each of these as we go through, but it seemed good to lay out the landscape to begin with. So finally, an employer can mandate that some or all employees become vaccinated. Then there are different ways to administer such a program. Some employers might administer the program directly, but that's primarily going to be healthcare related businesses because they would have someone on staff who could actually do the vaccinations themselves. And so they could do that all in-house on staff. That's not really going to be the case at most libraries. So the next closest thing you might have as an opportunity is to contract with an agency or a company to come in and administer the vaccinations for you on site or nearby, someplace that employees can get to. And then finally, an employer can, whether they're doing it voluntarily or whether or for incentives or rewards, or whether they're doing it as a mandatory program, they can require that the employee goes to any vaccine site that's off premises and turns in proof of vaccination to that employer. So this is kind of a mix and match process. Any type of vaccine program can be matched up with pretty much any way to administer it. So you can have different combinations there. We're mostly going to focus, though, on ways to administer on the last two listed for the reasons I already said, that a library isn't going to have someone on staff necessarily who's qualified to administer vaccines. Okay, so now I'm interested to know, just through the comment box, are any of you considering a mandatory vaccine program? I just have no idea what the thoughts are, among the different libraries. And so I'm interested to know that. And then I'm also interested to know if any of you are planning to do a voluntary program with some kind of reward or incentive. Okay, this is interesting to see your comments. And then I see Diane says they already have an encourage program, a program based on encouragement. So that's great. So that would be the other category, would be the encourage and educate approach, which in many respects is the lowest risk sort of program to take on. Risk in terms of various kinds of liability that could be incurred, or various laws that could be broken if you did one of the other types of programs, which are a little bit higher risk if you're mandating a program. And we'll go into a little bit more detail on that shortly. Okay. Recent COVID vaccine developments. I'm sure everybody is aware of this from following the news and from making arrangements to help people register for their vaccines. But the first vaccine became available December 2020 under FDA's emergency use authorization. And currently we have two vaccines that are FDA authorized. One is from Pfizer and one is from Moderna. The FDA is required to inform a vaccine recipient if the vaccine that they're administering is authorized under the emergency use authorization provisions, and they're required to inform that person that the person has the option to accept or refuse the vaccine. I mention that because when that advisement is made, it can be confusing if somebody has been told by their employer that they're required to get a vaccine, and then when they go get it, if they're handed a piece of paper that says, you don't have to get this vaccine, it's your choice. And so the difference there is just that the FDA isn't going to mandate that anyone takes the vaccine when it's in that emergency use authorization stage, but an employer under certain circumstances can do that. And the way that advisory is usually made is that there's a fact sheet put together by the FDA that's handed out to the vaccine recipient at the vaccine appointment. And if you are interested in seeing what those say, those are also available on the FDA website. So one point of possible confusion that you can anticipate and be ready for with some good communication. We're going to start with EEOC guidance that came down December 16th, I believe, of 2020. Yes. And this was a very important thing that the EEOC released, because it answers a whole bunch of questions as to how they're going to implement various federal anti-discrimination laws when it comes to these types of vaccine programs. We start with the EEOC because the Equal Employment Opportunity Commission is the agency charged with implementing federal anti-discrimination laws, most of them, and concerns about discrimination or about how to avoid discriminating against employees for various reasons related to whether or not they get a vaccine or why, are a significant potential liability in implementing a vaccine program. It's not the only source of potential liability, but it's probably the most significant one. So we're going to spend more time talking about ADA compliance than we are just about anything else today. And we will touch on other sources of potential liability when we get to legal considerations. But first, this guidance that I mentioned. The EEOC guidance is, I have a link to that on the resource page that will come up on the screen at the end. It's written in a pretty straightforward manner. It's question and answer format, so it's helpful. It is a helpful statement. It's broad. The broadest statement it makes is that equal employment opportunity laws do apply during a pandemic, but they don't interfere with or prevent employers from following the guidelines and suggestions made by the CDC or state and local public health authorities regarding steps that employers should take to help prevent COVID-19. So, as I mentioned before, things can change. The CDC and the FDA may revise their recommendations based on new information that they have, and you want to be sure that you're following their most recent information on maintaining workplace safety. Another guidance that was put out earlier, pre-development of a approved vaccine, was a pandemic preparedness piece that I also linked to in the resource page. And that was interesting because the EEOC came right out and said that if an unvaccinated person will expose others in the workplace to the virus, the direct threat standard is satisfied. A direct threat is what an employer has to find in order to, actually, that standard is going to come up over and over again very shortly. So you'll see where it falls. But the idea is that if you find that an employee would be a direct threat, then you would need to try and find accommodations that would lower, reduce, or eliminate that threat. And so the pandemic has made the direct threat equation easier to calculate because they've come out and made some statements based specifically on that. So a couple of other laws that the EEOC defends or prosecutes include not just the ADA, the Americans with Disabilities Act, but also Title VII of the Civil Rights Act and the Genetic Information Non-Discrimination Act and the Pregnancy Discrimination Act. And several of these are implicated in a variety of ways, but mainly when we talk through how the ADA works, that creates a pattern that's going to be pretty reflective of several other of these programs, which may have slightly different wording. And I see I lost an S here. Okay, so we're going to start with the ADA requirements. And just a brief background, the ADA has been around since 1990. It is a federal civil rights law that prohibits an employer from discriminating against qualified individuals with disabilities. It covers private employees with 15 or more, private employers with 15 or more employees, and includes state and local governments. So the library is generally going to be covered by this this law, and it's going to need to comply with it, with the ADA. And the ADA requires that an employer must provide reasonable accommodation for a known disability of a qualified applicant or employee unless it can show that doing so would impose an undue hardship. The ADA does a lot of other things besides just this. Well, I'm sorry, that's my background slide. I have another slide that talks about what the ADA requires here. And basically, it limits an employer's ability to make disability-related inquiries and to conduct medical examinations unless the inquiry or exam is job-related and consistent with a business necessity. The idea here is you can't ask someone, what's wrong with you? Is there a problem? Do you need to see a doctor because you're acting in a certain way? Or, things that sort of tend to ask someone to tell you about a disability they might have, that's for them to disclose and not for you to ask of them. So you have to be careful what kinds of medical information you seek from your employees. Hopefully this is not new information to you. And any medical information that you get from your employees needs to be kept separate from their personnel files and maintained in a confidential manner. And you can't exclude, here's the direct threat standard I was talking about. You can't exclude an individual with a disability from the workplace for health and safety reasons unless they pose a direct threat. And there's a whole formula for determining a direct threat that has to do with the length of the threat and the severity of the threat and the likelihood of the threat. But essentially, the EEOC has given us a little bit of a shortcut there by saying the pandemic creates a direct threat. If an employee is potentially at risk of spreading the infection, that's a direct threat because it's serious and it's lasting a while, and it can be very harmful. So that initial decision that the pandemic and the things that can happen as a result of the infections that are being spread with COVID-19, the initial place that this was discussed had to do with whether or not people can come to work, whether or not they can wear masks. If they have a disability where they can't wear a mask, is there some other way to keep them safe at work? And so that was the initial discussion of direct threat, but now it's still important because it is also going to relate to the question of if somebody doesn't get a vaccination, will they pose a direct threat to your workforce? And that decision is still going to rely on a number of things, which include how many people among your staff have already gotten the vaccine, and how closely does the person interact with other people, either other employees or the public. So there are individualized factors that need to be considered, but I've tried to sort of highlight the different words that have specific definitions. It may be helpful to know that a disability can include physical or mental limitations, and under the Act, it is an impairment that substantially limits one or more major life activities. The impairment is substantially limiting if it lasts for more than several months and significantly restricts the performance of one or more major activities. So these are the things that will help determine whether or not you have a situation on your hands that invokes the ADA. Okay. Now, that's all very clear, right? Not yet, but fortunately we have this EEOC guidance, which we're now going to discuss what it has to say about the ADA, and it's going to help make things a little bit clearer. It starts with saying, because you are not allowed to require a medical exam unless there's a business and job-related purpose. You're not allowed to ask questions about a person's medical health unless there's a business and job-related person. So the first thing they say is you can administer a COVID-19 vaccine to an employee, and that is not considered a medical exam for ADA purposes. So right there, administering the vaccine is not a problem. Even requiring the vaccine is not a problem. Requiring the vaccine is not a problem, even if it's still in its emergency use approval stage. The reason a vaccination is not considered a medical exam is because the purpose is not seeking information about impairment. You're not asking about the vaccine because you want to know if there's a disability. Rather, the purpose is preventing COVID-19. So legitimate purpose under the ADA, not likely to lead to discrimination unless you are kind of screening people based on disability and inability to get the vaccine for some kind of unfavorable treatment, and then that would be a problem. So while giving the vaccine is not a problem, before anyone gives the vaccine, whether it's a somebody contracted to do it on the employer's behalf, or whether it's a third party that has no relationship with the employer. They will need to ask certain pre-vaccination medical screening questions, and those questions are subject to ADA standards because they are likely to elicit information about a disability from a person who has a disability. And in order to do that, the screening questions have to be job related and consistent with business necessity, which, you're going to have to figure out if that applies to you or not. There's not a predetermined answer for that one yet, but there are some ways to avoid having to make that decision, because pre-screening questions won't trigger ADA protection if the employer makes the vaccine available to employees on a completely voluntary basis. And if an employee doesn't have to answer the questions, the employer can refuse to give the vaccine. The employer or the contractor providing it or the third party can say, if you're not going to answer the questions, I'm not going to be able to give you the vaccine because that wouldn't be safe. I don't know if your health merits getting the vaccine. So it's okay to refuse the vaccine if the questions aren't answered, but it's not okay for the employer to retaliate in any way. So it has to be either a voluntary program, or if the employee gets a vaccine from a third party who's not under contract with the employer, such as a pharmacy, and that information doesn't ever, the information related to the pre-screening questions, if that never gets to the employer, then that's not a problem for, in terms of ADA protection. It's like giving information to your primary care physician that your employer's never going to get. There's not an employment discrimination threat or risk there. Okay, so the guidance also does say that that if the questions come from the employer or somebody that the employer has contracted with to perform vaccination of employees, and the employer is requiring the employee to get a vaccine, in order to meet the standard of job-related and consistent with business necessity, the employer must have a reasonable belief based on objective evidence that the employee who does not answer the questions and does not get the vaccine will pose a direct threat to the health or safety of the employee themselves or others. So that's sort of how you would try and focus on that equation. It gets a little complicated. Like I said, this is not the final discussion on this point. This is really kind of a starting point for trying to lay down some background. The guidance also says that an employer can ask the employee to submit proof of receiving a COVID-19 vaccination, and that is not a disability-related inquiry. But the employer can't follow that up by saying, if the person doesn't have receipt of vaccine to submit to show that they've gotten the vaccine, the employer can't follow that up by saying, well, why didn't you get it? You knew you were supposed to. Why didn't you do it? That's the type of question that is likely to solicit information that the employer is not entitled to under ADA. And because of that, if you are doing a program where people go to a third party and then have an opportunity to submit proof of their vaccination in order to either comply with the requirement or to become eligible for incentives or rewards, then you might want to advise employees to submit only receipt of vaccination and no other medical information that may have accompanied that receipt when they provide proof of getting vaccinated. So far we've said that an employer can require the vaccine. However, that is subject to some pretty big exemptions. And the first exemption we're going to talk about, because it is required under the ADA, is the exemption for disability. So an employer with a mandatory vaccine program must provide an exemption for an employee who can't receive the COVID-19 vaccination because of a disability. And some of the things that you would consider in trying to figure this out are, does the individual pose a direct threat, which is an easier threshold to meet right now during the pandemic? Can the threat be eliminated or reduced by providing a reasonable accommodation? And if there is no accommodation that would reduce the threat to an acceptable level, or if the accommodation that might help would pose an undue hardship on the employer, which means a significant difficulty or expense, then the employer can exclude the person from the workplace, which is kind of a big deal because that's something that is generally avoided under the ADA. But if it's not safe and there's no way to make it safe, then you can exclude that individual. However, the employer cannot automatically terminate an employee even if they can legitimately exclude them from the workplace. So that puts the employer in an interesting situation. What has to happen if an employee wants to be excluded from the vaccine requirement, if it's a mandatory requirement, the employer and the employee will need to engage in a flexible, interactive process to identify options that don't cause undue hardship, which is significant difficulty or expense for the employer. And some of those accommodations might include allowing the individual to telework, to do their work, perform their work of their current position remotely, or to change the position temporarily that they hold to one that involves less contact with the public or other employees. If the person's current position doesn't really lend itself to teleworking, maybe there are other tasks that you can assign to that person temporarily that could be done either remotely or just in a way that involves less contact with the public or other employees. So depending on the size of your library and if there are areas that are less public than other areas and there are things that can be done in those less public areas, that arranging for that could be considered a potential accommodation. And if you can't find a useful accommodation, then the next, then another thing that might be considered is if having the person go on leave for some period of time, temporary leave for their position. This exposes a training need because if it's likely that you will have people, once you start having people wanting to become exempted or accepted from a mandatory vaccine program, your managers and your supervisors will need to have training so that they know how to recognize and respond to an employee's request for accommodation. That requires training because an employee doesn't necessarily come to you and say, I need to have a flexible and interactive conversation with you to determine if we can come up with a appropriate accommodation for my disability because I need that. More likely they might say, wow, I changed my meds and I need some time off to get this situation straightened out because I'm a little, woozy right now. And that should be considered a request for accommodations, even though it doesn't come out in the form that the statute is written. Your managers and supervisors also need to know who they should refer those kinds of questions to or requests to. And they also need to know that they are not allowed to disclose that an employee is getting reasonable accommodations, or that they also are not allowed to retaliate against an employee for requesting accommodation. So the idea is the employer doesn't have to make any and all accommodations that a person might consider asking for, but they do have to come to some kind of agreement and discussion with the employee about what might be a reasonable accommodation. And then if the employer does not consider the request reasonable, the employer will need to demonstrate how that is going to create a hardship for them. Okay. When I get started talking, all the parts are moving, the papers, the slides, it can get interesting. Okay. Title VII requirements. This is referring to Title VII of the Civil Rights Act of 1964. And then Title VII is basically, it is the part of the statute that says that you can't discriminate against any individual with respect to compensation terms or conditions or employment because of the individual's race, color, religion, sex, or national origin. So basically all of the other anti-discrimination, most of the other anti-discrimination laws that we're aware of sometimes as a civil, at the state level, that's considered the Civil Rights Commission that would handle that and civil rights laws. But the reason we're looking at this now is because primarily because of religion, because yes, an employer can create a mandated vaccination program, but there are a certain amount of exemptions that the employer can't avoid. The employer can't avoid the exemption for disability that we've already discussed, and they can't avoid a request for a religious exemption. So what does our EEOC guidance say about that? Under Title VII, an employer who requires vaccinations must provide reasonable accommodation for an employee who objects based on the employee's sincerely held religious belief, practice, or observance, unless it would pose an undue hardship. And in this case, because it's a separate set of laws from the ADA, undue hardship has a little bit lower threshold than to meet than the undue hardship of finding a reasonable accommodation for a person with a disability. So in this case, the courts consider it to be having more than a de minimis cost or burden on the employer. And burden should stop with N, but okay, so the EEOC cautions that the definition of religion is broad and protects beliefs, practices, and observations with which the employer may not be familiar. So the employer should ordinarily assume that an employee's request for a religious accommodation is based on a sincerely held belief. However, if the employer has an objective basis for questioning the religious nature of the exception, for example, if someone says, well, it's not really my religion, but it's my personal philosophy, or if they have a secular reason for not wanting to get the vaccine, then the employer can ask for a little more documentation or some supporting information that will help clarify whether or not it's part of the person's religious beliefs, sincerely held religious beliefs, that is the reason for them objecting to the vaccine. And then finally, again, similar to under the ADA, if no reasonable accommodation is possible, the employer may exclude the employee from the workplace, but may not automatically terminate the worker, which is kind of another way of saying you'll have to find some other accommodation. But anyway, we'll keep going. Indiana statute cases and plans. So to bring some of this to, we've talked so far just about federal rights laws. And now we're going to talk just a little bit about how does Indiana handle vaccine laws? How have we handled it in the past? And just a little background, all states in the United States require certain vaccinations in specific settings, such as for children entering school. All states provide medical exemptions to the vaccination requirement, and the majority of states provide religious exemptions. But a few provide an exemption for philosophical or secular objections. This comes from a law review article from 2016 called "Who's Calling the Shots?" And the reason we're looking at some of these, at what Indiana statutes say on this, is that we're trying to, and what Indiana cases say, we're trying to see in part what the history and tradition of Indiana's values regarding vaccination and public health are, and what exemptions have been considered important here in the Hoosier State. The idea being that our state legislature hasn't made any laws specific to COVID-19 or COVID-19 vaccinations. There is not a law in the books that says employers can require, employers in Indiana can require the vaccine. So we're looking at other vaccine legislation from the past to see how has it been handled as an indication of how the state's values line up with that. So for starters, we're going to look at the Indiana Code's vaccine requirement. There is a code section already in the Indiana Code that does require vaccinations, requires children who are enrolled in elementary school or high school to be immunized as determined by the State Department of Health. The statute lists 10 diseases, communicable diseases, such as diphtheria, pertussis, tetanus, measles, rubella, polio, mumps, varicella, if I pronounce that right, hepatitis A and B, and meningitis. So those things are on the list. But the statute also says that the State Department of Health can expand or modify the list of communicable diseases that require documentation of immunity as medical information becomes available that would warrant expansion or modification in the interest of public health. Now, probably no one is really discussing at this point whether or not children should have the COVID-19 vaccine in order to get into school next year, because the current vaccines that we have haven't been tested on children and aren't recommended for children. So that's not likely to be the next thing to happen. But we do know from the code that the parent has to prove that the child has been immunized unless the student is exempt under either of the next two statutes that we're going to look at. Oh.
One of them is related to if an employer is required to pay if the chosen accommodation is temporary leave. And the other question is someone's asking about verifiable, what constitutes verifiable documentation to support images?
Okay, I'm looking at.
You're not going to be hearing me, so if you
right.
Now, you'll want to repeat the question.
Okay. So I'm going to go ahead and look at and read these questions and see. This looks like a very long one. Okay, regarding a temporary leave concerning an employee who's unable or unwilling to get a COVID vaccine, does it require the employer to pay them during their time off? I understand those with benefits, there are options, but I have more part-time, no benefits right now. Okay, as we have I've already forgotten what this.
The question is basically, is the employer required to pay if the chosen accommodation is temporary?
So I think that probably you can't terminate the employee, so you have to preserve their position. You don't if you have no policy requiring you to pay, then you don't necessarily have to pay for leave, or if you can come up with some kind of I mean, this all is going to depend on so many things. It's going to depend on the size of your staff, and it's going to depend on boy, so I've been reading and reading about this policy, but you're asking a real world question that I'm not sure I'm entirely prepared to answer right now. So there's nothing that says that it has to be paid leave. And if there's a way probably to combine a certain amount of paid leave with unpaid leave to make it a little bit easier for the person to survive, then, that's probably a good thing to consider if you can. Let's see. And also, it depends on whether or not they have a disability, whether or not they have a disability or they're just refusing to do it. Because there's a difference. If they have the disability, you have to be careful not to discriminate against them on the basis of that disability. But if they're just refusing to do it and they don't meet one of the exemptions, then that changes the dynamic a bit. Okay. I don't know if that helped or not, but if not, feel free to get back to us and put it more specifically in writing, and we can try and look further into it. Okay, yes, that should be, and the question, should that be spelled out in the vaccination policy? Yes, and I have a list of things to consider putting into your vaccination policy. Okay, then the next one is, does that mean the employee could work remotely, or is it just excluded from the physical workplace? Yes, the employee could work remotely because there's no danger involved in letting them work remotely, no physical danger in terms of, communicability of disease. So if you can figure out a way for someone to work remotely, that likely is going to factor into what your reasonable accommodations are. And if there's a way to do that, you're going to be in a better position to defend the action that you've taken than if you don't come up with a way for them to do that. So that's a good thing to work towards, I think. Okay. So the Indiana Code recognizes a religious objection for students. If the child's parent objects on religious grounds, the objection needs to be in writing, signed by the child's parent, and delivered to the teacher or the individual who might order an immunization, absent the policy. And then there is also a teacher provision that doesn't specify immunization. So where you see where I have the ellipsis before and after immunization, the statute doesn't just address immunization there. It addresses immunization, testing, examination, and treatment. And so, but I was trying to focus in on the immunization language. There's a teacher provision that, because teachers are not required to get these same vaccinations that students are, but they may be asked to get some kind of a medical test, examination, or treatment. And if they object to that, that also needs to be in writing, signed by a teacher, delivered to the principal of the school. So this is just giving you a little bit of an indication of how you might structure the process for requesting an exemption. You might have a form that you ask people to fill out, and you probably would want to have that form looked at by your attorney to make sure you're not asking any questions that you shouldn't be asking on there. But you can, the idea of having to sign it and turn it into the boss, there's historical precedent for that. So that's kind of why we're looking at some of this. Okay, and then there's also long-standing tradition of providing an exemption for a student's health, and what the code says about that is if a physician certifies that a particular immunization is or may be detrimental to a student's health, then the requirement for that particular immunization does not apply to the student until such time as the immunization is not going to be harmful to the student's health. And these statutes have come into play in some old cases. The first one I'm going to mention is Blue versus Beach, which is an Indiana Supreme Court case from 1900, in which an unvaccinated child was excluded from attending public school during a smallpox epidemic. And there was some debate in the case as to whether or not there really was a smallpox epidemic, but the court found that the public health agencies have a right to determine if there is a risk of an epidemic, a threat or a danger of an epidemic, that they can require vaccination. Basically, the idea is if everyone gets vaccinated, they might be able to avoid the impending epidemic that would have happened if nobody got vaccinated. So you don't actually have to have the epidemic become full-blown in order to require vaccination to prevent increasing the size of the epidemic. So in this case, a parent refused to vaccinate a child because he didn't believe the vaccine was safe or effective. The child was healthy and did not qualify for the existing medical exemption. And the court said that the child was properly excluded from school in that situation. The plaintiff, Mr. Blue, the father, alleged that the vaccination in all cases produced a loathsome constitutional disease which poisoned the blood of the patient, frequently resulting in death, and was not preventative of smallpox. I found this fascinating because this was 1900, and what I learned from this case is that vaccines have been around for a long time, and vaccine deniers have been around for a long time, and religious and medical exemptions have been around for a long time. So these are not new hoops that you're required to jump through. They exist in at a variety of levels and in a variety of ways, under federal law, under state law. I just thought that was useful to observe. And then the second case, where there was an emergency resolution by the Board of Health excluding school children who had not been vaccinated. This was not considered unconstitutional, and it did not abridge religious or civil liberty. So in this case, again, the parent claimed there was no epidemic, and the court said that statute and ordinance vest the Board of Health with the jurisdiction to determine whether or not an epidemic exists, and the court doesn't need to get involved in that. The court also doesn't really need to make any decisions about whether or not the vaccine is effective, because that's really the job of the legislature and the State Board of Health. The legislature designating the State Board of Health the responsibility for making those kinds of emergency orders. And the reason there was no, at least one reason there was no finding of a violation of religious or civil liberty in this case is because the plaintiff did not, failed to actually argue how the action infringed on constitutional rights. So just a little dip in the history well to see how some of these things have been handled in the past. And then the other piece of state information that I wanted to share is a peek at the state's vaccine distribution plan. And I have a link for this plan on the resource page. And it is on page 11 of the plan is this three-phase release, concept of release. And it's a little dated, but it is what exists in the written plan. That doesn't mean they haven't changed it. The point here is figuring out whether or not the vaccine is going to be available for your employees, because if the vaccine's not available, you can mandate it all you want, but your employees won't even be able to comply. So something to keep in mind. Okay, what to consider? There's a lot that you can consider. I'm going to start with a list of policy provisions that you might want to consider. These are topics that you might want to address in your policy. I haven't tried to spell out for you how to do that because there are many decisions that are up to you to make there, and there are also many requirements that you have to stay within there. And it's going to be probably a complicated and time-consuming process. Actually, that brings me to another question. have any of you actually already written your vaccine policy for a COVID-19 vaccine, or did you already have in place any policies for previous flu epidemics that we've had in the state in past years? So just interested to know if you've done this work that we're talking about. You may have a product that is worth sharing to other people. Other people might be interested in seeing what product you have on that. Okay, so provisions you might want to consider. First is whether the employee is going to encourage, incentivize, I don't like that word that used that way very much, or mandate vaccination for all or part of the staff. Where it says all of the staff or part of the staff, it doesn't literally mean all, because people will have this opportunity for exemptions, but it means you could say, for example, if you had some employees, on the front lines interacting with the public all the time, and you have other employees who are maybe doing something completely different, mostly shelving books or not interacting so much with the public, you might have an argument for treating them differently. I'm not suggesting that you should try and treat them differently, but just that of all the different workplaces that there are, in some workplaces it might make sense, particularly larger workplaces, to treat the people who do deliveries out, to the public differently than the people who, I don't know, are in a back room ordering new books. Okay, how the employer will administer the vaccine program, that goes back to the overview of types of programs that I talked about earlier. The employer's policy regarding time off for vaccination or for potential side effects from getting the vaccination. What you will do in the event of a vaccine shortage, and what your process for medical and religious exemption requests will be. Also, you might want to consider what your response will be if somebody just refuses to get it rather than actually qualifying for an exemption. And if you're providing incentives for employees who are exempt, if you are applying incentives, then it's helpful to have some kind of alternative way to earn that incentive for an employee who is exempt on medical or religious grounds. So if everyone gets $100 bonus for getting their vaccine, or if everyone gets 2 hours off for the vaccine appointment, there should be some way for people who can't get the vaccine to also qualify for the reward or incentive. So in some cases, that's by doing some kind of training, health and safety training, or training regarding, COVID prevention and, decontamination of public areas. Anyway, something to allow those who would otherwise be shut out from participating in an incentive plan. Oh boy.
You're caught up on questions.
Okay, non-discrimination and non-retaliation provisions. Another thing that is thrown out there as an example of what could be included is whether the employer will cover the cost of the vaccine. I didn't put that on the list because it's not that relevant, since vaccines are available in the US at no charge. Although some providers may charge an administrative fee, so you could address that. And then if you are going to require a vaccine, it would be good in your policy to start identifying the job-related reasons for doing so. And I didn't quite get all the way through everything, but I got through most of the most important stuff. I'm just going to skim here a little bit. Here's some examples of what some retail, grocery, and other retail stores are offering their employees. So some real world incentive examples: $100 bonus, And employees with a religious or medical exemption can complete an education and safety course for the same bonus. Aldi's is offering 2 hours of pay per dose received. Dollar General is offering 4 hours of paid time, and that's probably for both doses together, so it's really the same. But Kroger's stated goal was to encourage staff to get the vaccine as it becomes available and motivating the workforce to optimize their health. It's actually probably not a bad idea to include a stated goal for your program. Anyway, Dollar General said, we don't want our employees to have to choose between receiving the vaccine or coming to work. There are lots of other possibilities of incentives, and you have to be careful to draw the line between a reasonable incentive and maybe an incentive that's too large and might create other problems, such as, how, whether it's considered part of their salary, and whether it's, how it's taxed, and how there are an overly large incentive can cause problems too, including, the last thing on this list of other legal considerations are the acceptable size of incentives and whether they could violate wellness program rules. Some other things that you would consider, this is all going to be handled differently if your employees are in a union, because then you have to deal with collective bargaining. It's a bargainable work requirement or work compensation. Workers' compensation, if you have a mandatory program, is going to be involved, because if you're requiring employees to get the vaccine and there's a problem, a health problem that comes out of that as a result, then that can become a workers' compensation issue or claim. And so some other legal considerations and some non-legal considerations that I listed out, things you might want to think about or do a little research on if you're concerned about them. And then here's just the takeaway on, my summary of 5 basic points to remember. Yes, you can require employees to be vaccinated even under the emergency use authorization. The employer must consider reasonable accommodations or allow exemptions for employees who can't take vaccine due to disability or other health-related concerns or sincerely held religious beliefs. The vaccination itself is not a medical exam, but the pre-screening questions are likely to trigger ADA concerns, except in certain situations. And it's okay for the employer to require employees to submit proof that they have received the vaccine. That gets me, I believe, pretty much to the end of my presentation. I have not really left a lot of time for questions, but I just want to say we're going to wind up here, but I'm going to stay and I'm going to stay on just a little bit longer in case people have more questions. I'd encourage you to go ahead and either type in your questions or your goodbyes if you're taking off now. And I am going to stick around here just a little bit longer.
Did you see Tara's question about whether or not they should offer paid time off if the person takes the vaccine when they're not scheduled? Did you already cover that? I was texting in this chat.
We talked about that, I think.
Yeah, I was trying to answer some other questions, so I wasn't listening. Okay, so then you should be caught up with questions.
There's a couple of new questions here. So here's what I'm going to do. I am going to tell Lisa that she is welcome to stop recording now.